Hi. So this topic is very interesting. When tenant becomes the owner of the property, or when tenant claims the ownership of the property, or how tenant claims the ownership of the property, if you don't take proper precautions, or if you don't follow what law is saying, today I'm going to share little information about how a tenant becomes the owner of the property. Now, before understanding how tenant becomes the owner of the property, we must understand what law says, how to give an immobile property, which could be a land, house, an apartment, to a tenant by the landlord. If there is an agreement which is less than 1 year, law says it need not be registered. If it is more than 1 year, law says it must be registered. Now, this is the first step of letting out your property to a tenant. And the second most important step is you have to accept all the rents by way of an account pay check or an online transfer. If you attract any TDS, inform the tenant to deduct the TDS. This is the second most important step which you must undertake while continuance of the tenancy. That is when the tenant is in your property. Now, this is the law. Now, obviously, very few people follow 100% law because law is always tough. Now imagine a situation where you gave your property to a tenant for 1 year on a 1-year agreement which is unregistered. It's perfectly fine under the eye of law. And after 1 year, there is an oral agreement between the tenant and the landlord, and the tenant is continuously in possession, paying the enhanced rent, and landlord thinks there is absolutely no problem with any sort of agreement when the rent is getting enhanced every year, and the rent is coming to his account properly. What is the problem? Landlord ignores the issue of entering a fresh agreement. Now, what does law say about this activity or about this relationship between the landlord and the tenant after the expiry of unregistered agreement of sale? It could be unregistered agreement of sale, or if it is more than 1 year, if it is registered agreement of sale also, what is the relationship between the landlord and the tenant after expiry of the lease agreement? The expression that is used in the law as per Transfer of Property Act is tenant by holding over. Understand the expression? He is holding the property belonging to the landlord in the capacity of a tenant, in the relationship of a tenant, but paying rent to the landlord with the consent of the landlord. Here, the landlord gave consent. The landlord is accepting the rent. The only point here is the lease agreement expired. There is no lease agreement. That is to say, he entered into the property with an agreement, but he is staying in the property after expiry of an agreement, lease agreement, but staying in the property with the consent of the landlord, paying rent properly with the consent of the landlord, paying enhancement in accordance with the consent of the landlord, then the tenancy is called the tenancy at or by holding over. It is fine. It is recognized in the law. Law recognizes it. He is not a trespasser. Remember this. Because once an agreement is expired, he becomes a trespasser. No, he doesn't become a trespasser. Now, this is one situation which is almost found in every landlord-tenant relationships. It doesn't come to court because rent is being paid by the tenant with enhancements. Now, the second type of tenancy or the second type of situation, the expression that is used in the IF, the law is called the tenant by sufferance. Now, lease agreement expired and the tenant is not paying the rent. Is he a trespasser? Law says no, he is not a trespasser even he doesn't pay the rent but stays in the property. Then the expression that is used in the eye of the law is called tenant by sufferance. Unlike the earlier one, it is called the tenant by holding over. Here who is suffering? Both are suffering. Let us not go into why that expression is used, but this tenancy is called the tenancy by sufferance, where the tenant is staying in the property belonging to the landlord as a tenant without paying rent and thus causing suffering to the landlord. Now what is the remedy available to the landlord? The landlord should immediately issue a notice for vacating the premises. If he is not doing so, then the tenant, remember carefully, listen carefully, the tenant is slowly acquiring the right of an owner. The tenant acquires the right of an owner if he stops paying rent and stays in the property for more than 12 years. When he is not paying rent, he is in the possession of the property adversely. He is not in the possession of the property in the capacity of a relationship between the landlord and the tenant. There is no relationship. Once a rent is not paid by the tenant, the relationship expires. He starts becoming owner. He starts acquiring the right of owner slowly over a period of 12 years. This is called adverse possession. The principle for adverse possession is the possession should be open, continuous, uninterrupted. If the owner or the landlord is least bothered about the property and the tenant is most bothered about the property goes to the tenant by adverse possession. Remember this. Now, it doesn't happen as easy as I explained to you. It doesn't happen like this. Why tenant claims adverse possession? In what circumstances tenant claims adverse possession? I will explain. Agreement expires and tenant pays the rent, owner accepts the rent in black without any proof for payment of rent. Now tenant manipulates the law when he comes to the court. Hope you got the point. If the court finds an iota of evidence, a little evidence that he is a tenant, then court decides the case in favor of the landlord. So the point here you must understand is, you must always accept the rent by way of white money, by deducting TDS. Even though he defaults in paying the rent when there is a subsisting lease agreement, whether registered or unregistered, no problem. Payment of rent, proof of rent is very important. You may think that the neighbors are the proof. No. Neighbors are thinking that tenant is the owner. You are thinking that you are the owner. When it comes to court want evidence. And the only evidence court relies on is the relationship between tenant and the landlord. And that is crystallized only by rent. Only by the payment of TDS that is deducted by the tenant while paying the rent. So remember, pay the rent in white amount, get the lease agreement registered. If these two precautions are taken care of, the tenant never becomes the owner, can never become the owner. Hope I am clear. A recent Supreme Court judgment also confirmed, and we all learn from those principles and share with you. I am leaving the link and snippets of the Supreme Court judgment in the description box. Kindly go through it. Thank you. Thanks for watching.